coverall. Thank you. Mr. Spivey, before we proceed, I need to share with you and remind you that you have constitutional rights and protections involved in this matter. First right is the right to remain silent. That means you do not have to make any kind of statement at all. You don't have to answer questions. You don't have to submit written paperwork that has your signature, especially papers that admit or confess to wrongdoing or violation of the law. You understand you have that right?
Yes, sir.
You have the right to a jury trial. That's where you and your attorney and the state's attorneys would pick 6 jurors from a random jury panel. Those 6 jurors would listen to the evidence, look at all the materials and testimony, and then decide whether you're guilty or not guilty. That's a jury trial. You understand that?
Yes, sir.
Right. The third right is a right to confront witnesses. That means that you and your attorney have the right to question, cross-examine, or challenge any witness who would testify in your trial.
Yes, sir.
That's a right to confront witnesses. The fourth right that we're going to talk about is the right to appeal. After all is said and done, you and your attorney would have the right, you individually or your attorney individually or the two of you together would have the right to demand that a higher court review the official record of this proceeding, the evidence, testimony, everything. If you decided to do this, you'd have to follow the right paperwork and the time limits that are involved. You understand you have that right?
Yes, sir.
And you also have the right to demand it. Now, this one, you have the right, and the state individually has the right to demand that this proceeding be held in the open public courtroom. That right applies to both of you. And because of the COVID pandemic, we're not doing that. Instead, both of you, the state and you, are agreeing to what's called a video conference that is doing it by computer where we see and hear everything. This proceeding is being streamed on YouTube, so it is public in the sense that everyone that wants to can tune in and see and hear everything. But it is not in the open public courtroom as the law and Constitution require. You understand you have that right?
Yes, sir.
All right, I'm going to show you some documents. Each new document will have repeated on it at the top what you see here. I call it identifying information. Case number 649445, the state of Texas versus Jarrett Jason Andrew Spivey, in County Court of Law number 5, Bexar County, Texas. Then after that information, it has the title of the particular document. This one, by the way, the title would always be, or usually would be in all capitals, bold print. This particular one is the state's consent to video conference. Did you review and understand this, and that is signed by the Assistant District Attorney, Caitlin C. Morgan?
Yes, sir.
Do you have any questions about it?
No, sir.
This second document, again with the identifying information, the title of this one is Discovery Acknowledgement. The very first line talks about a particular law that is applicable in this proceeding. That law is called Article 39.14 of the Code of Criminal Procedure. That law requires that the state share with you and your attorney and disclose to you all the evidence that's relevant concerning this matter, receipts, books, documents, videos, whatever is involved. That law requires that you be given access to that. This document is signed by your attorney and the state's attorney, Both of them are telling the world, and officially, they're saying that that law that we talked about has been obeyed. The next document with the identifying information at the top, this one is defendant's consent to video conference. That's where you agree to give up the right to have this or to demand that this be done in the open public courtroom. Is that your signature there where it says Jared Spivey?
Yes, sir.
To me, it looks like a F8, the number 8. But
I apologize for that, sir. I had to do my initials.
you don't have to apologize. The only thing, I'm teasing you a little bit because the signature is very unusual. Pardon me. All right. That's signed by you and your attorney. Now, the document you're being shown now, again, a repetition of the identifying information. This one is titled Defendant Waiver of Constitutional Rights and Court's Admonition. Big words, but it says that you're giving up certain particular rights and constitutional guarantees. This says that you were charged with driving while intoxicated. The third sentence says, in this cause, I hereby enter a plea. Will you read that for me?
Yes, sir. It's going to be the DWI second, correct?
No, sir. This says you're charged with DWI. And right at the top of the page for you, what does it say?
DWI first degree.
No, you're not reading what. Look at the top of the page there. Where you're.
I'm sorry, sir. In this cause, I hereby enter a plea of nolo contendere to the following allegations: driving while intoxicated.
All right. Is that true? You're entering a plea of nolo contendere?
Yeah. Yes, Your Honor.
All right. Now the rest of this document is divided into 15 numbered portions or divisions or paragraphs. The very first one talks about the range of punishment for the crime that you're alleged to have committed. The very first, there's a stack of a vertical stack of little boxes, and next to each one, it says a particular punishment for a particular time. This one, the very first box is going to be marked. It says DWI first, which is what you're charged with. What is that? What is the punishment there?
It says DWI first, $0 to $2,000 fine, 72 hours to 180 days in jail.
All right. So you're able to read, you know what these documents say, right?
Yes, sir.
The rest of this, Mr. Statson, as an officer of the court, did you review this document carefully with your client?
I did, Your Honor, and I went number by number, line by line, the full document.
Very good. Mr. Spivey, where were you born, sir?
I was born here in the United States, sir, San Antonio, Texas.
All right. So the record will reflect that you are a U.S. citizen. Did you review this document and then sign it with your attorney?
Yes, sir.
You have any questions about this document?
No, sir.
All right. This next document is titled Trial Court Certification of Defendant's Right of Appeal. This is where I certify to you. There's a stack of boxes again, and the fifth one, which is right at the top there for your convenience. It says that I'm saying this, that I find that this is a plea bargain case and the defendant has no right of appeal. Did you understand that?
Yes, sir.
I'll be signing that document. You have already signed it, so has your attorney. Is that true?
Yes, sir.
All right. Now, what you're seeing is what's called an application for judge-ordered community supervision probation. Again, a repetition of the identifying information at the top. Then the title is Application for Judge-Ordered Community Supervision Probation. Did you and your attorney review this document carefully?
Yes, sir.
Did you understand that this constitutes a written, legal, binding agreement between you and the court? The agreement is that under your plea, the court can find you guilty. I may find you guilty, and I will give you a punishment, which includes a jail sentence. But that jail sentence will be suspended or probated so long as you live up to 100% of the conditions of supervision. If you fail or refuse to live up to all the conditions, then the state can ask me to give you official notice, bring you in for a hearing, and if the evidence justifies it in my mind, then I can send you to jail for the amount of time that the sentence includes. And that's jail time. You understand that?
Yes, sir.
All right. Do you have any questions about this document?
No, sir.
All right. Scroll, please. The next document that you'll be seeing, my coordinators, well, this one is a personal data sheet. This whole thing is about your personal information. And it includes your address, date of birth, all the information about you, or the basic information. It says you're unemployed. How long have you been unemployed?
Actually, as of yesterday, I was having issues at my job, and I had to, unfortunately, resign or quit. But I will be looking for a job here pretty soon, though.
What kind of money do you think you can make?
I make about, I would probably say, from a full-time point of view, probably I would come home after taxes, maybe about $600-700. So, every 2 weeks.
Okay. Now, you single, married, or married, single, or divorced?
I am single, sir.
All right. Do you have any children?
No, sir.
All right. What kind of car do you have?
I do not have a vehicle at this time.
What were you driving when you got arrested?
It was a Jeep Grand Cherokee Laredo, 1999.
And where is it now?
It is in the impound. It is totally destroyed, and I just left it there.
Okay. And do you ever use your parents' vehicle?
No, sir, I do not. They don't let me drive.
Okay. All right. We'll show you now what's called a plea agreement. That is the agreement that you and your attorney have made with the state. I'll remind you that I don't have to accept this. By law, I'm required to say yes or no. I can say, yes, I accept this deal, or no, I do not. I reject it. Either one, I have to make that choice.
Your Honor, before you begin, may I point to two things on the plea agreement before you begin?
Yes, sir.
I believe the plea agreement is going to say condition interlock, and I've informed Caitlin Morgan that we're going to ask the court for the Smart Start Mobile because my client does not have a vehicle. And I was going to ask if you needed an affidavit stating that.
Yes, we will.
An affidavit, okay. I'll have that drafted for Mr. Spivey. And the other thing would be, although restitution is in there, I've spoken with Caitlin and Andrew this morning. We're going to be asking for a restitution hearing. So we ask that you do not include the restitution figure in the plea. We're going to ask for restitution to be determined with the restitution hearing in a couple weeks.
All right.
And that's it from defense counsel at this time.
We'll look at that momentarily. All right. The plea agreement has your name and the case number. The first two boxes that you see there will be marked. The first one talks about includes your right to remain silent. It's repeated again. The second box identifies you as a U.S. citizen, which you've testified to. Below that is a section with all capitals says defendant's acknowledgements. There are a stack of 5 vertical boxes. There are 5 boxes that are vertically assembled. Each one has a particular statement concerning your rights and protections. Did you see and understand what each one says?
Yes, sir.
All right. Mr. Stateson, do you agree that those 5 boxes were knowingly checked and that you all know, both of you know what they contain?
Yes, Your Honor.
All right. Then it's a section called DWI specific allegations. There's a check mark near a box that says state will proceed with DWI as alleged in the charging instrument. Now, at this time, what is your official plea to the charge of DWI?
I will, um, um, nolo contendere. I'm sorry, Your Honor. I don't know what to say.
Your Honor, when I had gone over this, I told him, are you going to plead guilty, not guilty, or no contest? I didn't say
No contest, sir.
So I didn't explain nolo contendere was the same as no contest to him. That's why.
All right, a nolo contendere, Mr. Spivey,
Yes, sir.
is essentially taken in this court as a guilty. However, there is a technical difference that Mr. Stateson has asked you to testify or to plead nolo contendere because it protects you from civil action. They cannot use that plea for any other civil matters or lawsuits. So it is the proper thing for you to do. Now, I hereby order you to appear in the offices of County Court at Law Number 5 so that your thumbprint can be affixed to the documents that are required under the Code of Criminal Procedure. You're sentenced 180 days, Bexar County Jail, probated for a term of 9 months. That's suspended for a term of 9 months. You're fined $500. Of that, $500 are probated or forgiven on the condition that you live up to 100% of the conditions of supervision. You will perform 24 hours of community service restitution. You will enroll in good faith and complete the DWI education program, the DWI victim impact panel. You'll submit to a TAP evaluation and follow the recommendation. You will have for 6 months in lieu of ignition interlock and on a condition of submission of a sworn affidavit by you that indicates that you do not have access to a vehicle, that you are not driving any vehicle whatsoever, and further, that the vehicle that you were arrested in has been totally destroyed. For the duration of the ignition interlock time that would have been, instead the time for the ignition interlock, you will have instead the portable alcohol monitor Smart Start installed. Scroll. Okay, now, Mr. Stateson, this document indicates that there was a agreement within the plea that your client would make restitution to Ivan Murado in the amount of $3,200. Now, what is the distinction here, or for what reason do you now ask me not to recite that?
Yes, Your Honor. I had attempted to clarify with the state last Friday. We didn't get the paperwork until today, but the $3,200 alleged restitution was a bill of sale to a vehicle about a month prior to this alleged offense. So the vehicle, my understanding is that it was restored or repaired. We never received a collision bill. I don't know if it costs less than $3,200 to fix it. I don't know if they bought a new vehicle less than $3,200. It's not a for-profit victim. It's to make the victim as completely as whole as possible. We just want to make sure that they're not double dipping. If their vehicle was sold to a junkyard for $500, they pocket and they get money to buy a new vehicle, or if they had insurance, a deductible. We're just asking to see if it was repaired, a collision amount, and I believe the court can set this for a restitution hearing at your discretion to determine that.
All right. State?
Your Honor, that's correct. We may not have the actual correct information on the restitution. If the state could just have 2 weeks to get that and for a restitution hearing.
All right, then the court will order a restitution hearing on this case. Presumably there will be testimony or documentation to that effect. All right, any questions, Mr. Spivey?
No, sir.
Mr. Statson, other than the order for the restitution hearing?
I would just like to add, Mr. Spivey had at one point told me he was employed at Lowe's. I did not know that he had subsequently lost his employment. Considering that, we would ask the court within your discretion to lower supervisory fees as much as possible. He does have to pay restitution. Although the fine was probated, we're very grateful, but we don't want to set him up for failure with 9 months. That's a very short time.
What says the state about that?
Your Honor, given that he could potentially pay $3,200 in restitution, the state would rather him pay that than, having the burden of paying the fees.
Now, which fees particularly are we talking about?
If the judge would allow the minimum supervisory fee.
All right. And the supervisory fee is set at the minimum, which is $25 a month. All right, any further question, Mr. Spivey?
No, sir.
Mr. Statson?
No, Your Honor.
Ms. Morgan?
Nothing from the state, Your Honor.
All right, then Mr. Spivey, I will require you to meet with Maricela Luna. She's what's called a CL